Good morning, everyone. It's 9 a.m. Rosie, are we ready to begin?
Yes, Madam President, we're ready.
Okay, so it's 9 a.m. and I'll call the meeting today on September 13, 2024, meeting of the SDCERS Board of SERS Administration to order. Rosie, do we have a quorum?
Yes, Madam President, we do have a quorum with the following members absent: Roberta Spoon, Thomas Battaglia, and Paul Kaufman.
Great, thank you. So moving on to Section 3, public comment. Rosie, do we have any public comments today?
Yes, Madam President, we do have a public comment for today, and it is Ms. Lorraine Gain. So, Ms. Lorraine Gain, we would like to invite you to the reserved speaker spot to come up to for your comments.
Sorry for my slow method of getting up here. My name is Lorraine Gain, and I do appreciate the opportunity to be here and to speak to you today. I am here to request your support and approval for my disability retirement, and if possible, to ask the board to grant the motion as proposed. At the Disability Review Board yesterday, I was able to speak to the injuries I sustained and how they have affected my physical and emotional health, my life, and my career with the city for the last 21 of my 31 years of service. Truthfully, I was quite overwhelmed by the motion presented yesterday. I had no expectation that such a motion would even be considered. And it is my hope that the members of this board can put this all into context and understand that as my drop was nearing an end, I was completely unaware that I was even eligible for a disability retirement and uninformed of the process and the expected time frame for an application. This information that was not afforded to me in advance by SDCERS or risk management. This created a delay with SDCERS that exacerbated my disability application process that ultimately was denied by SDCERS due to a material dispute regarding the date of disability as reported by the SDCERS physician, Dr. Stephen Trudowski. This conflict was created by the SDCERS own physician when he backdated my date of disability to the same date as my drop retirement service date, and that criteria for receiving a disability retirement was not in dispute. Unfortunately, this one simple act that was unintended of any malice on the part of myself or Dr. Stephen Trudowski set into motion an extremely stressful and financially destructive process that has had significant negative impacts to my life. The phrase renders retirement necessary was something that I would have never expected to alter my disability retirement to the 2-year process it has taken to bring me here today. Some of you may ask why I would even fight for this. It is but a small tax advantage that is now going to take me over 8 years to recover. Some would say it's not even worth it. But to me, it was about the principle of the matter. It was about my integrity. Excuse me. And after all I have suffered as a result of my injury and my lifetime disability, this process was actually the greatest insult to my integrity in my person. To treat me as though I was trying to manipulate the system to garner something that I was rightfully due, and something that has had no real effect on SDCERS, or has no real effect on SDCERS. So while I do not know if there's any legal recourse for SDCERS to reimburse me for my legal expenses, I would truthfully hope that this board would consider passing this motion to grant me both my disability retirement and reimburse my legal expenses to make me whole. efforts to make me whole. And hopefully, it will serve as a reminder that this board is endowed to act with the utmost integrity, fiduciary responsibility, and with a genuine altruism towards all of its members that it serves. And that this SDCERS board will further take the opportunity to put in safeguards in this process so that others who may come after me will no longer have to endure the negative effects and financial expense of having to simply fight for what is right. And even if there is no recourse for reimbursement for me, at least I can hope that in the future, no one will ever have to suffer through this process. I just thank you for your consideration.
Thank you, Ms. Gain, for your comments. Are there any other public comments, Rosie?
No, Madam President, we don't have any others.
Okay. So moving on to Section 4, approval of the consent agenda items, service retirements, drop entries, drop retirements, training, and board agenda calendar. Before I call the motion for the approval for these consent items, would a board member like to pull one of these consent items for a separate vote? No? Okay. So hearing none, do I have a motion? Okay. Did it pass, Rosie?
Just 1 second, Madam President. With all votes in, this motion passes 8-0.
Thank you. So this finishes our consent agenda. Next, we will move to Section 5, Business Operations. And we have 2 information items on our business operations agenda this morning, starting with the first information item, our annual fiduciary training. So I will turn it over to Johnny to make the introduction.
Thank you, Lisa Marie. Good morning, everyone. Here to present your annual fiduciary education is Ashley Dunning, a partner and co-chair of the Pension Benefits Investment Group at Nossaman. If the board recalls, the board selected Ms. Dunning as its fiduciary counsel in January 2024, but Ms. Dunning has a long history at SDCERS. She was actually my fiduciary counsel here at SDCERS when I started in 2010. So a warm welcome. It's been a pleasure to work with you all this year, and good to see you here again. A little bit more about Ashley. She has provided fiduciary governance and litigation counsel services to retirement systems and boards since 1998. She is fiduciary counsel to CalPERS, New York State Teachers Retirement System, the majority of our 1937 Act retirement systems, the city of Fresno, Los Angeles, San Francisco, and of course, San Diego. I've asked her to give a very detailed, substantive presentation to help you with your fiduciary duties as you tackle all the issues that you'll deal with today and in the future. I've also asked her to address 2 new cases that are possibly relevant to what we do here. If you could squeeze those in your meaty presentation, that'd be great. Specifically, we want to talk about Los Angeles County Employers Retirement Association versus County of Los Angeles, where the Court of Appeal up in Los Angeles determined that the retirement association there had the authority to create employee positions and pay scales despite the county plan sponsor's disagreement to do otherwise. And that appellate decision seems disconnected to a decision that happened in early 2000s when CalPERS tried to do something similar. So we'll see how that case maybe affects our authority as a board and what we can and cannot do. The second case that we'd like you to talk about is Loper Bright Enterprises versus Raimondo, Secretary of Commerce, where the United States Supreme Court found under the Federal Administration Procedures Act that federal courts should no longer give deference to federal administrative agencies' interpretation of law when the federal statute's ambiguous. That's despite having that deference given to the agencies for the last 40 years under what's known as the Chevron Doctrine. So with that, welcome.
Thank you, Johnny. Lovely to see you all today. Thank you for having me for your annual fiduciary training. And I look forward to having a robust discussion with you that includes questions, comments? I have some hypotheticals here, so let's make it as interactive as is your pleasure through the chair. So, starting out, we're going to just set the table here with a definition of what a fiduciary is, and then who is and who is not a fiduciary in the context of administering the SDCERS plan. We will then launch into a discussion of the basic fiduciary principles that guide fiduciaries who administer public defined benefit plans in California. And those will look familiar to you because we've gone over some of them previously in the context of specific decisions this board was making. But I have elaborated on them more here for purposes of this more general training. And then I have hypotheticals for those different types of aspects of your fiduciary duties. And then we will end up with a statement, a comprehensive statement of what it means to be fiduciarily compliant, which is a mouthful. All right, so first of all, what's a fiduciary? The key here is that you have discretionary authority or control over the management of retirement plan assets. Or plan administration for the benefit of others. So for the benefit of members and beneficiaries of SDCERS, this is not your money, this is other people's money, and you're administering it and investing it for the benefit of them. And you have the duty, or that you have the duty to put the interests of those members and beneficiaries above all other interests. And here it's not only an or, it's an and in terms of how SDCERS trustees are to operate. So therefore, by definition, all of you and all of the executive officers of SDCERS are fiduciaries. And you therefore owe duties of loyalty and care, and we will talk about both of those. To whom? To SDCERS members and their qualified beneficiaries. So that's really important. You just don't owe these duties to anybody. You owe them to the members and not to anybody who they might be connected to, but to their qualified beneficiaries. As to what do you owe that duty? You owe it not as to every aspect of their life, but simply as to the benefits that are due to them by SDCERS. It's really important to think about that because as you think about these duties that you have to your members and beneficiaries, it's not all-encompassing as to their lives. But it does relate to the benefits that are owed to them by this organization, by this trust fund. So again, benefits due to them by the retirement system. It's important to realize that not everyone who interacts with SDCERS, and therefore with each of you, is a fiduciary, either to SDCERS itself or to the member of SDCERS. You encounter a lot of different people in this work. You encounter, of course, your plan sponsors, so representatives of the city or of the airport, of the port. You encounter employee organizations, associations, other state agencies, certainly your investment professionals, trustees of other pension systems that you'll encounter at conferences, for example, and members themselves, unless they're on this board. It's important to note that they are not, unless by contract, as I noticed here, investment professionals, they are not fiduciaries. And so simply doing what others do is not an appropriate act. What is to be considered is what is appropriate for this group, this board of fiduciaries to these plan members and beneficiaries.
I have a question. So our general consultant is not a fiduciary?
Your general consultant should be a fiduciary to SDCERS.
Okay, thank you.
Typically not considered to the members and beneficiaries under California law, but to SDCERS itself and the board, just as I am a fiduciary to you. There are 6 duties that I'm going to go through that are particular to public retirement boards in California. They are very similar, if not exactly the same, as fiduciary duties of public retirement boards across the country, though we have an articulation of some of these duties in the California Constitution that I've tracked in this slide. And so that's why the phraseology looks the way it does. So first of all, duty of loyalty and duty of care, you're familiar with both of those. Those are what you will see in any fiduciary duty training. Typically, you'll also see duty to diversify investments. That's not necessarily exactly modern portfolio theory, but it comes from that similar idea. You do have a duty to diversify unless it's not prudent to do so, and we'll talk about that specifically. This language about assuring competency of retirement system assets to pay promised benefits, it comes from the California Constitution. We'll talk about that. Fifth, this is important. A duty of prudence includes the duty to defray administrative costs, administrative expenses. And then finally, and we'll talk about this, also the duty to administer the plan in accordance with plan terms and other applicable law. You are not to pay benefits that aren't due under your plan. You're not to pay other amounts that are not due under your plan. And so that is an important part of your responsibilities as fiduciaries. Duty of loyalty is articulated through the exclusive benefit rule and the primary duty rule. And these are core to trust principles that under the California Constitution, which is at the core of the SDCERS decision that Johnny asked me to talk about, Article 16, Section 17, and other applicable trust law. Fiduciaries need to discharge their duties, and this is the language, solely in the interest of and for the exclusive purposes of providing benefits to participants, i.e. members, and their beneficiaries. So you are only to use trust funds for the provision of those benefits and administrative costs necessary to administer those benefits. And that duty to your members and beneficiaries is to take precedence over any other duty. So we talk about certain other constitutional responsibilities that you have, but this makes very clear that your primary duty is to secure the vested retirement benefits of your members and beneficiaries. There's a duty articulated in Article 16, Section 17 of the California Constitution to minimize employer contributions and defray reasonable expenses. But again, those are secondary to the primary duty. And note, this obligation to minimize employer contributions is not a fiduciary duty per se, in the sense that your employer is not the one to whom you owe a fiduciary duty. But you are supposed to run the plan efficiently, effectively, diversify your investments appropriately, such that you're not inordinately increasing plan sponsor costs. That's the benefit and beauty of a defined benefit plan that's pre-funded. You're able to do that.
Ashley, could I just back you up just one and ask you a question about the minimizing employer contributions? So that is, we are the ultimate arbiters of that, correct?
Absolutely.
So we're the decision makers as to whether we adequately minimized employer contributions and defraying reasonable expenses.
In consultation with your retained actuary, which you are required to do. It's an actuarially funded plan, and your actuary is required to make recommendations to you such that you can, in an informed way, minimize employer contributions.
Yeah, I was going in a bit of a different direction, and it has a little bit to do with that SDCERS thing, but I guess the question is, we decide to add 10 people to our administration. We're the ultimate arbiters of whether that is appropriate and whether we are being reasonable.
Subject to judicial review, you are the ultimate arbiters, yes.
Thank you.
I do have a question further back.
Yep.
When we talk about the members that we owe our duties to. So we have some 10,000 members, some of whom are close to retirement, some of whom are newer, some of whom are in the middle. Just playing out a thought exercise, if I was to take the net present value of the obligations of each of those individuals and stack them up today, if the scenario is that 65% of our obligation belongs to those who are, let's say, the first bucket of people who are newer in the program, would my fiduciary duty be to think about how my decision will affect those 65%? I guess is what I'm trying to understand is when you have such a spectrum of obligations, what is the construct? Because a decision, they're not nuanced decisions. Some of these are very black and white decisions. They're very binary decisions. And so in the context of that, and when you have a spectrum of obligations, what is the appropriate construct to think about?
That's a fantastic question, and I have a slide that sort of delves into it, but let me approach it right now just because you asked the question. First of all, it's not a zero-sum game. And your ultimate responsibility is to pay people the benefits that are due to them under the plan and to fund the plan in a manner that allows you to do that. Which means, and we talk about this in some of the slides, that there may be only one person in the entire plan who's eligible. I'm giving a ridiculous hypothetical, but there may be only one person who's eligible for a disability retirement in the plan. And it's going to cost a lot, just in this hypothetical, to pay that. Of course, you pay that person their disability retirement if they're entitled to it, even if it's just one person. Similarly, you may have a lot of people who have an interest in getting, and I do have a hypothetical on this, sort of legacy type benefits as opposed to pepper benefits. You can't give out benefits that are not provided under the plan simply because you think it's fairer to have the same level of benefits to people under the different plans. So you kind of have to take your members as you find them. But there are issues such as, for example, your active members are paying contributions into the plan. Your deferred and retired members are not paying contributions into the plan. Of course, decisions on contribution rates impact only one subset. I wouldn't weigh interests in that context. You just address what needs to be paid by the active members in that context, recognizing that you may have a retiree group coming to you asking for something that is important to them, but may need to be considered in the context of the larger plan. Continuing on with this fiduciary duty of loyalty, which is what we were talking about there in those series of hypotheticals, if the board were to put a plan sponsor's interest or a particular union's interest or some other party's interest or certainly your own self-interest, which creates all sorts of other legal problems, ahead of the overall best interest of the members and beneficiaries in the security of their vested benefits. I've chosen every one of those words very carefully. That would not be consistent with the exercise of your fiduciary duties. It's really a conflict of interest rule. Whose interests are you serving? The overall best interest of your members and beneficiaries or the interest of another? And the answer needs to be you're serving the overall best interest of your members and beneficiaries with respect to a topic relating to the trust. Related to that is this notion of, whether you're an agent for another, and the answer is you are not an agent for the one or the group who appointed or elected you to the board. It's recognized under California law that you all come to this board from different places. You are elected by actives or retired, safety, general, ex officio, appointed by the city. But once that occurs, you are here as a fiduciary. You're co-fiduciaries to one another, and you have a single fiduciary responsibility as a board. And the California Constitution speaks to this point in Article 16, Section 17, which I mentioned before. And that provision was put into the Constitution as the result of a voter initiative known as Proposition 162, commonly referred to as Prop 162, in 1992. And the context for that initiative was when the state, the governor, Governor Wilson at the time, was trying to take over the actuarial function of CalPERS. So it would be very nice if you're the one who owes money to be able to control how the determination of what you owe is done. And that's what happens when you take over an actuarial function in that way. And what that proposition did, among other things, is it made very clear that the actuarial function of a defined benefit plan in California is controlled by the Board of Retirement, or Board of Investments if you have one, but here the Board of Administration. So that was one of the reasons for Prop 162. But it is much broader than that in terms of the way it articulates the authority and responsibility of boards of retirement. I'm using Board of Retirement there generically because they're boards of administration, Board of Investments, Board of Retirement. Because it says notwithstanding any other provision of law, boards have plenary authority over the administration of the retirement system and the investments of their assets. And then it lays out an articulation of various different subject matter that specifically are impacted. This LaSera versus County of LA decision is really important because of what it says about the California Constitution's Article 16, Section 17. It's a published decision. As your general counsel noted, it just came out. It is subject to a current petition for review that was filed by the county. But even if review were granted, it's a published decision, it's good law. And it arose in the context of LaSera, which is the largest of the county retirement plans, determining that in order to properly administer its plan, it needed to have some additional classifications of employees at the organization and needed to pay them a higher amount than they were currently being paid. And in response to that, the county rejected some of those classifications and some of those salary requests, asserting that it had the authority, the final say on those matters. And what the Court of Appeal said is that the fiduciary board, which is the Board of Retirement, or in that case, Board of Investments. No, actually, it was Board of Retirement. Board of Retirement has the authority. I'm sorry, it's both boards in that case. It's complicated, but the retirement boards have that authority, and not, as in the words of the court, not the politicians. It was really setting up this important construct of fiduciary boards versus political boards. And political boards will be driven by all sorts of motivations that are valid, but not fiduciary in nature. And therefore, when determining how prudently to administer a retirement plan, to Trustee Brewster's question, that is the responsibility of the fiduciary board. And the Court of Appeal, therefore, concluded that LaSera was correct in asserting its plenary authority over this aspect of the administration of the plan, and that the Board of Supervisors had a ministerial obligation to approve and adopt those classifications and salary schedules.
Ashley, first, a factual question. The employees in question at LaSera, were they county employees or employees of the pension plan?
Is that a trap?
No, ma'am.
I'm
Could be to be.
So under the County Employees Retirement Law of 1937, SERL, which is the law that applies to those plans, the statute identifies them as county employees,
Okay.
and yet they're appointed by the retirement system.
Okay.
and under the statute as well. And so one of the points of argument between the two parties is what that means. With LaSera taking the position that county employee language is used simply to ensure that they remain part of the retirement system. They're eligible for all of the rules that for public employees that you get as a county employee, but not with respect to who has the authority to hire, fire, set compensation for, determine classification of.
So the impact of this ruling, does it carry over to California pension plans that are not county plans?
The analysis of the decision was done primarily under the California Constitution, which applies to all plans in California.
Okay.
But it also applied the County Employees Retirement Law, so SDCERS. So it was under both.
So we are not a county plan, obviously.
You are not, but you are subject to the California Constitution. So it will be important in terms of the California constitutional language in that decision. As your general counsel noted, one of the primary points of argument asserted in the litigation related to how a case called Wesley versus CalPERS versus Board of Administration does or does not impact this analysis, with the county arguing that Wesley required a different result, and the Second District Court of Appeal who made this decision concluding that, number one, Wesley did not require this result, and number two, Wesley was decided and was incorrectly. So that is one of the things that the Supreme Court now is going to need to assess when considering whether or not to grant the pending petition for review. They'll need to assess whether there is a conflict between the two courts of appeals that must be resolved by the Supreme Court or not. And that's to be seen.
And is that scheduled? Is it on the docket?
It is on the docket.
So we may get a decision by June of '25.
What are we now? We're September. I would be very surprised if you don't get a decision before the end of the year on the review question. Yeah.
Thank you.
So Ashley, just going further along the lines of what Cliff's asking, because I'm intrigued by this 1937 Act issue versus the Constitution aspect that obviously applies to us. So let me give you a real case, an example. We talked at the last board meeting about the idea of having our general counsel also be our chief compliance officer, and whatever. There was a discussion about that. Let's say that we decide we want to have a standalone chief compliance officer, and we want to pay him X, or her, and the city says there's no such classification, so we're not doing that. And I'm just using this as examples,
hypothetical,
right?
Right.
So I'm not trying to put Johnny out of a job right away, but
Give him more time for his other job.
Yeah, yeah. Well, that's a good point. I hadn't thought of it that way. But using that example, is it your opinion based on this case that we could do that?
I think you have a very strong case to support authority of the retirement board to administer its staff and pay its staff as it deems prudent, subject to judicial review, if under this decision.
Thank you.
All right, so that is the LaSera decision. And this is the slide I was referencing in response to Trustee Wynn's question about all the different interests of your various groups of members, that there is a recognition in the law, and this applies for all sorts of trusts, where you have income beneficiaries and remainder beneficiaries in the private context or in the regular trust context. And here, similar, you have your active members and your deferred and retired members. And there's a recognition that those interests can be cross-cutting and that they're complex. And so you are granted a fair measure of discretion in terms of weighing interests to the extent that they actually are in conflict with one another. As I noted in my initial response to Trustee Wynn, it is not a zero-sum game, though. It's not as though you only have a bucket of money and that's all you have. You have to pay the benefits that have been promised under the plan, and so you have to fund the plan in a way that you can timely pay those benefits. Here's our hypothetical one, and this is on the fiduciary duty of loyalty. So we have Samantha, who's a member of your board. She's also been active for many years with various organizations that focus on addressing homelessness challenges. An active member of the retirement system presents to the board in public comment, urging the board to invest in local companies that build affordable housing. Your CIO has previously recommended a higher allocation to real estate with a component that includes affordable housing. So in this context, what would be fiduciarily appropriate considerations both Samantha and other members of the board on this topic? Any thoughts? Yes.
In terms of potential conflicts of interest, there needs to be disclosure at a minimum by Samantha of the organizations where she's been involved, where she may have more than a casual point of view, where she may have actually engagement, where there might be somehow either the reality of or perception of a benefit to her.
Certainly, if she were an officer with one of the organizations or had some financial interest in them, that would need to be discussed beforehand with your general counsel. But in terms of influence, bias,
I mean, there's a trade-off, isn't there, where there's expertise in an area that may not be understood broadly and with great depth?
but what is it? What is the expertise that that we're looking for? Is it how to solve homelessness problems in San Diego, or is it something else?
No, sadly, because homelessness is a terrible, terrible challenge everywhere, it seems, the duty of loyalty is to the plan and to the ability to pay the benefits that are promised. First and
Right, so
foremost.
you're looking to the prudence of potential investments. Your CIO has already proposed real estate investments that include an affordable housing component. So it's not as though the discussion is off limits. It's simply that it's to be conducted in the context of whether it's appropriate within your portfolio from a prudence perspective and a loyalty perspective.
I would think that the CIO's proposal would be a broad scope affordable housing exposure, probably a national footprint. Samantha is specifically saying there should be an allocation to San Diego. In and of itself, first blush, knee-jerk reaction shouldn't be a no. It should be, is that supported by an investment case? And if in the process of choosing affordable housing managers, if they happen to have an allocation to San Diego, great. If there is, I think what's more intriguing is if we were to say we would like that manager to take a deeper look at San Diego, and if the projects in San Diego meet all of their check boxes, there's no reason why I would think from an investment perspective we should shy away from it. But I think it needs to be recognized that there is that line, and it has to be supported by an investment case that stands up to all types of questions.
That's exactly right. That's a great comment. And the local investment dynamic is a real one that exists in a lot of different areas. And there are a lot of political pressures with respect to that particular topic. So, Trustee Wynn, you're absolutely right that it's the investment case that needs to be looked at. It's your diversified portfolio. Typically, you're investing nationally, even internationally. So is it prudent to have that local focus? It may or may not be. I'm not putting my thumb on the scale on that, but simply saying that that's what needs to be analyzed for you by those with expertise in that topic.
But on a practical basis, it's easier for those, I mean, it's a classic principal agency conflict, right?
Right.
Like the people who are making the decision are not the people who own the assets. So from a practical basis, if I'm a manager, I would rather not have to stand up to that scrutiny. Although San Diego is legitimately and maybe on many levels of superior investment opportunity, I just would rather not have to deal with those set of questions. So I would just look at opportunities in El Paso on a practical basis, and human nature being human nature, and being sort of in the investment space myself. So I guess the deeper question here for me, theoreticals aside, is how do we provide coverage or cover for our investment staff and our managers to be able to say, to propose San Diego as part of the portfolio without having to feel extra scrutiny to have to justify.
I think the premise should be that any decision that you're making can withstand whatever scrutiny is applied to it.
Right.
And I also think that one should not be dissuaded from making investments simply because there may be scrutiny.
Yeah, and actually, I mean, I think if, we follow what Louis is talking about and put them in the mix, right, whoever's being recommended, and if they stand up to scrutiny and are equals, then why not, do good things for the community if the options are, in our view, are basically balanced.
Subject to the comment that Chair Harris made about conflicts of interest and full disclosures and all of that, I think it's fair to include all options.
Yeah.
And certainly the legal guidance that's out there, both in a governmental context as well as on the private side under ERISA to date, has been consideration of all of those factors is pertinent, as long as what you're looking at is risk-adjusted return to the portfolio.
Yeah, thank you. I would not want us to feel like we would want to avoid.
Well, that was my point. Simply, I agree with you that the fact of scrutiny does not mean you should shy from something that may be prudent and appropriate. We'll talk about later that good faith is not enough. So doing the right thing from the perspective of whomever it is who's judging what's right needs to be stated sort of with reserve, because good faith is not enough. It has to be backed by evidence.
I just want to get back to the hypothetical, just so I'm clear. So although Samantha is involved with homeless issues, I don't see her having a conflict in this particular case.
I didn't frame it as necessarily
Okay.
invoking a conflict in the sense of a disclosure recusal conflict.
Okay.
Though it could, as I believe you sort of aptly noted, that there's a possibility there, depending on what that level of engagement is.
Okay.
I was focusing more on purpose, and the purpose needs to be consistent with your your responsibilities as a trustee when making investment decisions.
Thank you.
Great questions.
Can you give me an example of what a possible conflict might be for Samantha? Because I'm just not seeing.
So if
that.
Samantha were on the board of a nonprofit that might be building some of the affordable housing,
Okay.
that would certainly be a conflict. And there are all sorts of nonprofits that build affordable housing. So.
Okay.
Okay, fiduciary duty of care. So this is the second of the 6 duties that I enumerated earlier. And I've quoted the language from the Constitution, which is prototypical fiduciary language relating to the duty of prudence. All of those words are important. So it's being careful, it's having the skill, it's using the prudence, it's using the diligence. So all aspects of that. Then prevailing, so it's not 20/20 hindsight, but it's what was known or could have been known, should have been known at the time. that, and this is a mouthful, but one should say it all together, prudent person acting in a like capacity and familiar with these matters. So it's not just a prudent person, it's not just a lay person, a careful person, it's somebody who knows what they're doing with respect to the topic that's implicated. That they would use in the conduct of an enterprise of like character and with like aims. So administering a defined benefit plan, for example, investing the assets of a multi-billion-dollar plan. Consider carefully, as I say here, the particular expertise needed to address a topic within the board's jurisdiction. So is it a disability retirement matter where you're considering whether there's competent medical evidence? Is it a legal matter that implicates your fiduciary or other responsibilities in terms of applying the plan terms? Is it plan administration, and you should be talking with your CEO and or others who report to him? On plan administration, is it investments? Should you be consulting with your CIO and your investment consultant, et cetera? And the question, if you're challenged, is whether the fiduciary at the time you made the decision were using the appropriate methods. I'll talk further later, pretty soon, about other ways that fiduciaries' decisions can be challenged, even if your methods are perfect. But your methods do matter. And I note in this bullet point below that reasonable consultation with experts is important, whether it's your in-house experts or your external experts or both. That's not a substitute for your independent exercise of your responsibilities. I mentioned earlier, good faith is not enough, and I repeat it here. So this is an important principle of fiduciary law. Just because you think something is the right thing to do doesn't mean it's the fiduciarily appropriate thing to do, particularly when administering a trust fund, such as yours. So here we have two examples. One is the board member who's convinced that a particular investment action is morally right, but the systems CIO and investment concluded that it's not appropriate for SDCERS from a risk-adjusted return perspective. This might be a divestment issue, it might be an investment issue, could go either way. And the board member advocates to other members about doing the right thing. So that's the language that you kind of need to be careful about. The second example should look familiar to those of you who are familiar with SDCERS's history. The board's concerned that service credit purchases will be too expensive if interest is applied to purchase prices as required by the plan. And the board thus adopts a program not to apply interest to such purchases for a period of time. This is not exactly SDCERS's history, but it's sort of similar. So not applying the plan terms. If the plan terms say service credit purchases need to include an interest component, that's what you need to do, even if it seems unfair.
So Ashley, that is City of San Diego versus SDCERS that you're just sort of referring to, and I just wanted to speak to that issue, which is that ruling essentially said that a board cannot essentially add a benefit that is not outlined in the plan.
Right. It said once the board has determined that a cost-neutral service credit purchase would cost X, you can't charge Y just because it's not fair to charge people X.
In your view, yeah, you have to follow the plan. And
once you've exercised your discretion to determine what the plan means. So what was interesting about that, and sorry to interrupt, but there was an element of discretion that was necessarily afforded to the board in consultation with the actuary in determining the price in the first place. But once that decision was made, it needed to be applied. That's what the court said. It wasn't as though the plan itself had the term in it.
And you and I have discussed this, but by extension, I believe that ruling indicates that you also can't give any less than is required by the plan.
You should not be paying people less than the plan requires, correct?
or that whatever it takes to qualify for a benefit, you can't decide, yeah, that's unreasonable and we're not going to give you the benefit anyway.
So if a person is entitled to a benefit under the terms of the plan and the way that the plan is administered by the organization, then certainly that benefit needs to be paid. I think one of the things that we've talked about in the past is process and what level of what process needs to be involved with respect to determining an entitlement. And that is very important, because you're not, it's both sides of the coin. You're not to pay somebody a benefit that's not due. Similarly, you are to pay somebody a benefit that is due.
Yep, thank you.
Yeah, it's simple as pie. Not simple, but that's why you're all here in this very important role as fiduciaries of this fund. The duty of care, as I noted, when we talk about this prudent fiduciary or prudent fiduciary standard, you have to use a few more words to make it accurate. So the way I've sort of summarized it here is prudent fiduciary with expertise dealing with a similar enterprise. That's as short as I could get it. So you don't need to be the expert, but you may need to consult with an expert in order to comply with this standard. You certainly do as to certain aspects of your business. You're not the doctors, you're not the actuaries, you're not the investment professionals, you're not the lawyers for the plan. And you remain ultimately responsible after considering all of those inputs. I do think it's important to articulate specifically that you have in-house staff who are experts in these areas too. And so that is consultation with experts when you're talking to your CEO, your general counsel, chief compliance officer, CIO, et cetera. There are also outside retained experts with whom it's important to consult. Your actuary is the number one that I think of, even for plans who have actuaries on staff, but certainly an investment counsel. I hope fiduciary counsel from time to time, if that I can be of use. But very importantly, in terms of your investment consultant and your actuary.
Can I follow up on that real quick?
Of course.
So what happens in a scenario where prudence is itself changing as a definition? So hypothetically, we wake up and ESG is now considered highly prudent investment methodology. And there's no dispute. There's loads. Well, I'll take that back. The inflection point is what I'm trying to get at. It's when it's changing, right? Once it's already acknowledged by everyone, then prudence has already been redefined. So that's not what I'm asking about. What I'm asking about is in that point, when they're in that inflection point, when there is sufficient data to question, and there are experts, consultants out there who are now, let's say, two very defined camps. And we go to our investment conferences. We hear this divergent of opinions. Internally, we have a conversation. We are in agreement that that is the new definition of prudence. Our existing consultants and experts who we have are not going on record to agree with that, whether they believe it or not, whether it's a business case or not, but they're not on record. And so there's a couple of layers here, I guess I'm asking. Is one is, is it within the trustees' authorization to say, hey, we need to look at revisiting who our experts are, who are more aligned with how we think of the world. That's one. Two is, in that inflection point of when prudence itself is being redefined, what is the cover for trustees to be able to lean into a new set of what is prudent?
Ashley, before you answer that, I was just thinking as Louis was talking about inflection points, because there was a period in time when pension funds were investing only in fixed income. And then they evolved to now we have this full diversification. So at one point, fixed income was prudent. But then over time, it was determined that moving away from solely fixed income is prudent. So it's almost, that's a similar case, I'm thinking. To add to
And the law actually changed on that particular point. So originally, you were only allowed to be invested in what was authorized by the list. And then that changed in 1984 to expand to allow other types of investments. And then 1992 with the Pension Protection Act, with Prop 162, it opened it up to well-diversified portfolio, basically, which allows you a lot more latitude in terms of assessing what's prudent so that you can be in other types of private investments, et cetera. The comment about ESG, I think one needs to sort of, my view on that is one needs to be more specific always about talking about whether something's an environmental risk, a social risk, or a governance-related risk, rather than lumping it all together as if there is a particular lens that one should look at as to everything that would necessarily be prudent or imprudent. But on your more fundamental question, not relating to that specifically, but just how do we deal with the evolution of knowledge? I think the response needs to be you stay informed, which is what you do through having presenters come to you, having well-respected and informed consultants, attending the right conferences. We're having a discussion offline about, what are the right conferences. That's within your judgment, but they should be ones that are appropriate for this type of organization. There's a pretty recent U.S. Supreme Court case called Tibble that was an ERISA case, so in the private sector, not private fund, not governmental, but it talks about fiduciary duties of trustees of pension funds with respect to investments. And the court did note what we know, which is you're not a day trader. You're not assessing every day what's the move to make. You're a long-term investor. But once something is known, and there the issue was whether the particular type of investment involved should have been invested under the cost approach permitted for institutional investors versus retail investors. The court said it was a breach of the duty of care not to be investing under the lower cost structure for an institutional investor. In other words, you got to stay on top of things. It doesn't mean you have to know immediately, but you have to stay on top of it enough so that you can make adjustments as you monitor your portfolio through regular quarterly reports or whatever sort of regularized periodic reports you receive. There was one comment, do you switch consultants to have someone who's more aligned with your values? I'd be careful about that. I think that you should be working with consultants whom you have concluded as a group are well-informed, are providing outstanding advice to you, appreciate the responsibilities that you have as fiduciaries to maintain the fund, to pay the promised benefits, and to invest the assets in accordance with that. So, how people fall on a particular topic with respect to, say, climate change, I would not use as a litmus test, if that's what I was properly inferring from the question. Mm-hmm.
And I would just say that individually we all, we are responsible for our own individual voting records. So just because the board does something, you vote based on your informed view of prudence as well. So just because the board ends up doing something, if you have a no vote and something does go wrong with that decision, you can rest a little bit more easily that, hey, I was on the right side of that, so should some negative consequence come from that. So it's both as a group, we exercise prudence, and also individually.
I think that's right to a point. You're all co-fiduciaries as well, so it is important to speak up, to participate in the decision-making, and then you vote as you determine individually is the prudent approach. I do list some ways in which to provide prudent oversight here, which I think are also responsive to Trustee Wynn's question, the careful review of board materials, so that's been prepared by your staff and your consultants, communicating with staff about those materials, participating in board meetings, as I just mentioned, and then these educational opportunities, cost-effective ones, that are focusing on topics within your jurisdiction and consistent with your policies. That topic comes up, not surprising, well, maybe not surprisingly, maybe surprisingly, it comes up a lot with certain in plans about what is the right use of system assets to educate trustees. And so just think about that. Fiduciary duty of care includes the process and soundness of the analysis matters. And I mentioned that earlier. It doesn't require the fiduciary to guarantee specific outcomes, but requires a prudent process. So how you do things is important. However, substance matters too. So your prudent decision and prudent process will only withstand scrutiny if you are subject to judicial review. If it is not arbitrary or capricious, and the deliberations that you have and the materials that are presented to you and that you discuss relating to topics need to be rationally related to the decision that you make. And even before the Loper decision, which I mention on this slide, and that's the one that's the shorthand of one of the two cases that overturned the Chevron doctrine. I already had this concept in my fiduciary presentation because it's something that I've observed over time, which is, and it's in this SDCERS case that we were talking about earlier, City of San Diego versus SDCERS involving service credit purchase cost is a great example. If the court believes that the board has done something that's not consistent with the plan, they're not going to defer to you. And so I actually don't see a huge amount of dissimilarity between the way the courts have gone in California and this Loper decision, honestly. Even though I know it's a watershed moment in the federal courts under the Administrative Procedures Act. We have a whole other line of cases in California where there's some deference afforded, certainly. There's great deference afforded to the state retirement plans and possibly SDCERS under the Omaha decision where something's a technical matter requiring expertise that is specific to the retirement system. Courts may continue to be willing to afford you great deference. But courts have also said in the county situation, in a couple of recent cases, we'll give them due consideration because there are 20 of those plans that operate under the same law. So one might do something one way, others might do it a different way. So it's due consideration. So this language that's in Loper, that they will give careful attention to the judgment of the executive branch to help inform, that may help the court inform their inquiry, sounds to me somewhere between due consideration and some level of deference. And so it may be that courts in California end up affording even less deference to administrative agencies. It's possible. But I think given the level of expertise that is required with respect to certain aspects of your business, for example, how do you prudently fund this plan on an actual basis? How do you construct an investment portfolio that is prudent? That is core to your plenary authority, subject to your fiduciary responsibilities. And so I expect that courts will continue to apply the arbitrary or capricious standard, which is inherently affording you some level of deference, because two boards can reach very different decisions, and neither of them are arbitrary or capricious. It depends upon the circumstances presented to that board and the judgment of that board.
So Ashley, in the Prop B case, the unions appealed it, right, originally, and they appealed it to a state, I can't remember the name, but labor relations board, essentially. And that board said, city, you can't do this, whatever. The interest groups appealed this. It goes to the appeals court. I sat in on the appeals court discussion, and the question at that point was, and so this doesn't have to do with SDCERS specifically, but to that labor board, are you to give, the public employment,
PERB, Public Employees Relations Board.
right.
Yeah.
Their attorney argued you should give great deference to us because we're the experts in this area. The appeals court in that case said, yeah, we're not doing that. We're going to look at this de novo, right? We're going to take it, look at it from top to bottom. And so that argument went back and forth. The appeals court obviously didn't side with the PERB, I guess it's called. Then it goes to the Supreme Court, and they said, yeah, you should have given them great deference, basically. So the question is, do you believe that this Supreme Court case, and I think you talked to this to a certain degree, but do you think that would have gone differently now that that Supreme Court case has been decided?
I'd have to go back and look at that specifically, but I don't think they cited the Chevron doctrine, because I'm pretty sure that this California Supreme Court did not cite it. So I don't think it would be directly applicable, and I think we will still see the Supreme Court and Court of Appeal affording appropriate levels of deference to administrative agencies that are conducting the business that they're required to.
Based on their expertise.
Based on their expertise.
Thank you.
Yeah. They're not going to try to substitute their judgment for the judgment of an agency where the court thinks it's a well-informed judgment. And this Alameda Health System case is a really good example of that. That wasn't a Supreme Court case, but it was a Court of Appeal case from this year, where the Alameda Health System was arguing that that county retirement board should be basically charging them contributions calculated in a different way. I mean, that was the crux of the case. They said it was about having the retirement system do more studies of how much they would owe if the plan were funded on a percentage of liability rather than percentage of pay basis. So just as SDCERS uses a percentage of pay methodology for determining how much your plan sponsors are required to pay into the plan, so too has SDCERS for its existence. And AHS thought that they would owe less under this other methodology. And so the issue really was about authority, responsibility, fiduciary role, though that was complicated by the fact that no fiduciary duty was owed to the employer. Two of the members also were plaintiffs. And the Court of Appeal agreed with the Superior Court that the SDCERS board had exercised its discretion appropriately There was nothing arbitrary or capricious about its decision not to continue to study actuarial methodologies that didn't use, and that there was there was no reason for them to engage in additional studies or to change their methodology. And that was based on some level of deference because it was an arbitrary capricious standard. So what does prudence look like? Acting consistent with the laws and the plan governance documents. So we've talked about that quite a bit in the context of these various cases. You really need to listen to your general counsel when your counsel's telling you what the plan provides, what it authorizes, what it doesn't authorize. You also will have board policies and procedures, and those should be consistent with the law. They may extrapolate from the law and apply certain principles more generally across the organization, but they need to be consistent with the law. Where aspects of fiduciary duty are delegated, and we talked about this in the investment context, but it applies generally, periodic and systematic monitoring. You need to ask questions and to review materials to assess the facts, the analysis, et cetera. Document your decision-making through your board meetings are all recorded, so you have all of that. You also have a comprehensive backup. And you're continually trying to improve. So to also back to the point that Trustee Wynn was asking about, you are to try to continually improve. So as there's new information in the market, as there's new information generally, cybersecurity is a huge area, whatever it may be, that's the risk of the moment or among the risks of the moment. You continually assess how are you doing to be able to mitigate those risks. I've talked a bit about experts already. This slide is on that topic, and I've talked about it in other presentations to you, and that is consult with experts. Those you're consulting with need to have the expertise that is called for with respect to the decision that's at issue. And if you're not going to follow your experts' recommendations, you need to have a good reason that's grounded in the expertise itself. Not some other reason for making a different decision. So now we get to hypothetical number 2, the duty of care. Board member Morris is personal friends with an ailing active member of the retirement system who's applied for disability retirement. Morris has spoken with the member about the application. The competent medical evidence establishes that this member is not permanently incapacitated under the applicable legal standards, and the retirement system staff recommends to the board that it deny the application. The applicant attends the board meeting at which the application is considered and speaks to the board about the application, urging the board to grant it. What are and are not fiduciarily appropriate considerations for all board members, and in particular Morris, with respect to this topic? Ideas?
Well, I think we have a specific policy on this,
Okay.
saying that board members shouldn't be directly communicating or advising people applying through the process.
So in that context, would Morris now need to recuse?
Yes.
Okay. Good. Anything else?
I just say I think that's different from somebody coming to a board member and saying, I think I'm disabled on the job and whatever, and for us to say, well, there's a process for that. Here's who you call.
Certainly. And it is understood that you are all, a number of you are active members of the system. You know people. That's not, that you're not supposed to be off limits from saying hello to or asking something about SDCERS. The issue is how the trustee responds. And the response needs to be to direct the person to the right place at SDCERS, or the right, whether it's the website or somebody specific at the organization, rather than giving information or opining on their rights in that context. Okay.
Ashley, I have a question.
Of course.
We have, and we're going to talk about this later, a policy that allows for non-voting members on the investment committee. Would they have the same fiduciary responsibility that we have?
Excellent. Tell me a little bit more. It allows non-voting members to sit in, and then
And advise, I would imagine.
Members,
Right.
they're not on the board.
Right, they're non-voting
Oh, okay.
members.
So non-voting, but they're not members. They're not members of. Can I have a
I could
clarification?
clarify.
Yeah, and
Sure.
I was thinking about it because I know we're going to talk about it later, so I just want to understand
Yeah.
how they fit into the context of
It's
the
a good
fiduciary
question, Michelle. Thank you. So historically, the board has felt at one point in its history that it wanted people on the investment committee with some institutional investment experience, and the members appointed to the board or elected to the board didn't feel like they had that sufficient information. So we have a ability to have people on the investment committee who were not appointed, elected, not part of the actual 13 board members created by the charter, who sit on the investment committee, vote as an investment committee member, but not as a full board member. So they make essentially recommendations as part of the investment committee.
I see. Okay. So if we think back to that definition of
Excuse
who.
me,
Yep.
very important, I think. Currently, the investment committee has decision-making capabilities that may not go to the full board.
Okay.
So I think it's important.
I think it is, but I think the answer would be the same.
Fine.
Which
Just so
is
you're-
that.
Just so you're fully informed.
Right, no, that's really helpful, thank you. Going back to the original slide that I had about who is a fiduciary, the description of the role that these people have puts them right into a fiduciary role. So yes, they are fiduciaries. And in terms of the decision-making question, under California law, when you're looking at it, a decision-making from a conflict of interest perspective, for example, the question is somebody participating in the decision-making, which includes influence. So even if you're not taking the vote, if you're influencing a decision-making, then you are participating in it, and all of those rules apply.
Everything's falling apart. I'm going to repeat what I thought I heard, just so I can understand. So, a non-board member sitting on the investment committee without voting rights, but have the ability to speak and get involved in discussions, that individual has all the fiduciary responsibility that everyone else has.
I would think so. It's similar to your CIO. Your CIO doesn't vote.
Noted. Thank you.
Okay, third duty, fiduciary duty to diversify investments to maximize risk-adjusted return. I added that last part because I was asked one time when I was presenting on this, well, what's the purpose of diversifying? So to make it clear, it's not just diversifying for the sake of diversifying, it's with a purpose of maximizing your risk-adjusted returns. And this is a specific provision in Article 16, Section 17. Diversification is generally considered based on the plan's entire portfolio. So it wouldn't be appropriate to just look at one small aspect of the portfolio and say, is that diversified? Or the standard is the whole portfolio diversified? Now we have a diversification of investments, hypothetical. Board member Xavier is a retired private equity manager. Xavier is passionate about private equity investment opportunities and is a self-professed contrarian as to any other investment types in the public or private markets. Board member Xanadu is, I wanted to choose names I was pretty sure nobody had. So Xavier maybe, probably not Xanadu. Xanadu is active with a group that's urging public retirement systems nationally to divest from fossil fuels, citing climate change risks. The Retirement System's Chief Investment Officer and Investment Consultant are presenting the Retirement System's annual asset liability study, and they're proposing various alternative tilts in the allocations of the retirement system, all of which result in a well-diversified portfolio, but with varying levels of anticipated risk-adjusted return. I hope that sounds familiar, at least the third bullet point. Retired member of the system presents in public comment to the board and urges the board not to adopt any of the recommended asset allocations and instead to adopt policies that will remove all fossil fuels from the portfolio, citing the work performed by board member Xanadu in other contexts. A private equity manager who used to work with board member Xavier encourages the board to increase the allocation of private equity beyond that which is proposed in all of the recommended alternatives. From a fiduciary perspective, what considerations should board members take or not take into account with respect to this topic? Thoughts?
Well, I guess you really have to strip away those external recommendations and focus on what are the best investments for the plan.
Right, looking at the various recommendations that have been presented to you, but not pulling in others that are not within what your expert consultants have advised are prudent. Okay. I'm sure you've all been following or have followed over the years various divestment mandates that have come out of the state legislature. To date, they focus on the state plans rather than the city or county plans. The California Constitution, I mentioned Article 16, Section 17 has those various subdivisions. One of them is G, which is quoted here. And that provision says that the legislature may by statute continue to do that, but then it has what we call the fiduciary savings clause here. And that is, it can do that provided that the prohibition satisfies the standards of fiduciary care and loyalty required of retirement board pursuant to the section. So nobody's off the hook with respect to that. It means that if a divestment mandate is set forth in the government code as to SDCERS or any other plan, then the retirement board needs to determine, may we comply with that in a manner that is consistent with our fiduciary responsibilities, or would complying with it not be consistent with our fiduciary responsibilities, and so we will not comply with it. And this is a real live issue all over the country right now, whether it's divesting from different asset classes or different companies. And so boards are having to grapple with the fiduciary consequences of those divestment mandates.
So to expand on that, I've read, and many others here may have read also, about certain states, say, for example, Texas that comes to mind, where the state of Texas officials have decided that they don't want to do business with money managers
Right.
that may pursue certain sort of top-down, almost philosophical approaches to investing. And they have very large plans in Texas. So it's rather a powerful club from a business matter for these different money managers, for example, to perhaps change their approaches. But can a local plan in California, if that scenario somehow were, this is hypothetical, of course, were to come down from Sacramento, that we don't want you doing business with XYZ types of managers because of these policies or practices that they may pursue, would we under that hypothetical have authority to disregard that? Because if it would be our view that as fiduciaries exercising our care and duty of loyalty, that we think it is better on a risk-adjusted return basis for the benefit of the plan members to stay with those money managers. Long, long, long sentence, but I hope you're following.
No, I was following. You'd have to have the documented support for that conclusion, but if you did have it, then this provision explicitly gives you that out.
Yeah, Ashley, so it was a fascinating process. It wasn't this year, I think it was last year in the legislature, where they were posturing to put forward these things to instruct CalPERS to invest in a particular way. And essentially, to my reading of it, CalPERS was saying, you can pass that, but we're not going to follow it based on what the Constitution says. And it seems like they negotiated kind of with the legislature that that's going to make us all look bad, that you pass this and we don't follow it, and so the legislation was withdrawn. But ultimately, CalPERS and maybe CalSTRS were just invoking this and saying, we can't just do this because you pass a law.
This applies to all of the plans in California. So anyone who would be subject to a divestment mandate has this fiduciary savings clause recognized within the California Constitution.
Have you seen an example where a certain prohibition satisfies standards of fiduciary care?
Well, yes, that happens not infrequently. I mean, there are certain of the mandates within California law that apply to the other plans that are being applied. So those boards have made the determination that they can comply with them consistent with their fiduciary responsibilities.
So those boards have decided that they would prohibit investments in fossil fuel, for
Well,
example.
it's not. Well, actually, fossil fuel is one that's actually currently in the litigation right now. There are the three city plans in New York, 3 plans within New York City, divested from fossil fuels, and are in the middle of litigation over that divestment. But that those boards decided, they're fiduciary boards, and they decided to divest.
And so you said there are examples of of boards who successfully defended their decision to prohibit, and I'm just curious what those are.
You
Or
mean
did
in court cases?
Sure.
Or just generally?
Generally.
I was speaking generally, that there are boards that have made certain divestment decisions in California consistent with, that are set forth in statute.
And they were tested and
No, they haven't been tested.
they haven't
no.
been tested, okay.
But they go through the whole process, and so.
Can you provide some examples of what was divested? I'm just curious.
Well, just drawing, it's in the 7500 section of the government code, so divestment from Sudan, divestment from tobacco, divestment from Iran, divestment, just various different things. So with nuances to all of those. Mm-hmm. Thermal coal. Next duty, fiduciary duty to control actuarial services and assure competency of the assets of the plan. So this is the language from the Constitution that speaks to this topic. We've discussed it. We've discussed what the genesis of it was in terms of the state trying to take over the actual function of CalPERS, but it applies equally to all of you, relates to the funding of the plan. We talked about it in the context of your recent decisions about how to fund the plan. The O'Neill case I have spoken with the board about before was one that involved the Stanislaus County Employees Retirement System or Association, and there the challenge was to the board asserting that it had not complied with its fiduciary duties of care and loyalty with respect to how it was funding its retirement plan and actuarial related decisions that it made, and reserving decisions that it made in the fallout of the Great Recession. The court ultimately concluded that the board's decisions did satisfy the duty of prudence, and after trial also concluded that the board had complied with its duty of loyalty in the specific context of that case. Here's our fourth hypothetical. The board's actuarial funding policy includes layered amortization that results in some tail volatility when layers reflecting larger unfunded liabilities are paid off. Your consultant, your consulting actuary presents 3 different approaches to managing this tail volatility, all of which have differing impacts on employer contribution rates in the short term and or in the long term. The actuary states that it recommends 2 of the approaches, but notes there is a third alternative, which results in the lowest immediate employer cost, and that it's a reasonable option, but is not recommended. This might sound familiar. An active member of the system presents in public comment to the board and urges the board to select the alternative that results in the lowest employer cost in the short term because her employer's already constrained budget is preventing it from giving raises to its employees. A retired member of the system presents in public comment to the board and urges the board to adopt the alternative that results in the highest employer cost in the short term, expressing concern about the security of her retirement benefits if funding of those benefits is delayed. So we're seeing all the different interests coming to the board and presenting. Department head from one of the retirement systems participating employers presents in public comment and argues that the board should reject both the actuary's recommendations and the other option and instead use a different funding method that it argues is fairer to it, given its own employment practices. Might also sound familiar given the case I just described to you. What are fiduciarily appropriate and inappropriate considerations for board members to take into account with respect to this topic?
Ashley, you forgot about the part where the plan sponsor says that there'll be layoffs if you don't do this.
Well, I get the flip side of that, which is we can't give raises, but yeah, right. I mean, no, this was not really very hypothetical. We've lived through this. We can leave that in the past.
May I ask?
Let's leave that. We've talked about that enough.
But
Yeah.
the bullet point about the department head coming in and saying, there's, my kid studied actuarial science and I've got a better approach.
Right.
We can disregard that, generally speaking.
Well, that was the whole brouhaha that happened that led to the Alameda Health System case. Not my child does this, but I have a different actuary who would calculate it a different way, and I'd like you to do a study so that you can assess how much we would owe using that different methodology.
Well, that's kind of like venue shopping, isn't it? I mean, it's sort of like our crisis 20-some years ago where people urged, fire that actuary and get another actuary who'll give us, a more desirable number.
Right.
Okay.
I would push back a little bit on that. I think in this hypothetical, we put a tremendous amount of faith in the opinion of one organization, the actuary. And as with anything, I think it's important to have a second opinion with anything. And so it's coloring outside the line of your hypotheticals here, but in a situation like this where a tremendous, incredibly important decision is being made hinging on the coverage that's being provided by the actuary reports, that it would make sense to have a second opinion. It doesn't necessarily have to be coming from the son of a board member, but I think it would be prudent to have a different opinion because actuary science is highly vulnerable to assumptions and certain decisions in the calculation.
Well, it is very common for that reason to have actuarial audits. So you'll have your regular every 3 to 5 years actuarial audit, and there's nothing fiduciarily inappropriate about asking another actuary to opine on a topic that your consulting actuary is opining on in order to obtain additional expertise on that topic. So that's a very fair point. It doesn't mean you have to. It doesn't mean you should, but it doesn't mean you shouldn't. It just means under the circumstances, you need to assess what's being asked. And in the context of the Alameda Health System case, their actuary wasn't saying, we can't do studies on using this different methodology. They said that we'd have to make a lot of assumptions about certain things that were actually material to the determination of whether or not it was going to be accurate or not. But then it was up to the board to decide, do we want to continue down this road of doing additional studies using a methodology that we're not persuaded is better and that has these assumptions that need to be made that make even the study that would come out of it vulnerable.
And I would point out that I think our actuary in this hypothetical provided 8 scenarios, all of which they felt comfortable were reasonable.
Well, right, but then it gets to the question of what's an option versus a recommendation, which we talked about in that context. And what we're really looking from your retained advisors are recommendations. I think I gave the example that I kind of like, though I'm not sure if it's a good one, is, you have an option to walk across the street on a red. Would I recommend it? No. So be wary of options that are not recommended to you. Fiduciary duty to defray administrative expenses. So we're nearing the end of the presentation here, but all of these duties are important. The assets of the trust fund of the retirement system are trust funds, which is why you're fiduciaries, and shall be held for the exclusive purpose of providing benefits, as we've already said, to your members and beneficiaries, and defraying reasonable expenses of administering the system. So that's in the California Constitution, and it is articulated in some of these cases relating to fiduciaries of pension funds. This Tibble case I mentioned earlier is an ERISA case, but it recites the Restatement Third of Trusts, which has been recited in California case law, applicable to trustees of pension funds, public pension funds. Cost-conscious management is fundamental to prudence. So as with a lot of these duties, it doesn't mandate a specific course of action, but that you need a prudent process to make sure that the expenses that you're incurring are appropriate. And you do so through the adoption of various policies and then the application of those. Hypothetical 5 is on this topic. The board has an education policy that permits periodic travel for pre-authorized training for public retirement system trustees, but limits the cost per trustee. Board member Phillip requests an exemption from the policy to attend a conference occurring in Switzerland and requests reimbursement for 1, business class travel, and 2, an additional weekend stay, which results in lower airfare but higher hotel costs. Board member Paul requests authorization for the same business travel, citing a desire to have an additional opportunity to socialize with fellow board member Phillip. What fiduciary issues are implicated by this hypothetical? I'm making you work. But if you don't want to, we can move on. Any thoughts?
Well, they should be fine economy. You can't stay an additional weekend. I mean, this whole trip wouldn't even be authorized, actually, for us, because we don't travel internationally.
So you've adopted some limits within your travel policy. And it will depend upon the type of plan, how investment decision-making is delegated or not. Is it really appropriate? Is it needed? Maybe, maybe not. But under your policy, you've said not. Okay, so that's helpful.
So to the question of appropriateness, so let's say board member Phillip has a very specific expertise, and it's on a subject that we are currently discussing. And this conference in Switzerland is the preeminent place for this discussion, and we would like Phillip to go there to bring back sort of best practices and knowledge for us. So there's a very significant rationale. And currently our policy is no international travel, but in this case it seems to me like it would be a prudent use of expenses for a very special purpose.
Then that would be the discussion you'd need to have as a board, and the board would need to make a decision about whether an exception was warranted under those circumstances.
Right. And flying business, again, it seems exorbitant, but it does allow for sort of better mindset when you get there, ability to do work while you're on the flight, and there are reasons for it other than the luxury.
So those would all need to be discussed, right?
But fair to say, this one doesn't, what you're talking about doesn't inform bullet 3.
The socializing issue, right?
We would always say no to Paul, regardless of what he has.
Oh, dear, Paul, I'm sorry. I didn't mean to name you a trustee named
Yeah,
Paul.
I felt targeted, but it was supposed to say
That was
Louis,
not
not
intentional.
Philip. You should have had Louis instead of Philip, and then it would be more accurate, too.
My bad. Oh, there are, yeah, well, maybe it was this Paul. Maybe I meant, yeah. I didn't intend. This was not, this is true hypothetical. All right, final duty, the duty to act in accordance with the plan document and other applicable law. We've talked about this quite a bit. The California Supreme Court case that I mentioned here is the Alameda decision, and that was a case where the court made very clear that retirement systems are required to apply the plan that they're administering, and not to contract around it, not to provide benefits that aren't authorized by the applicable statute in that case. Board member Martha develops an understanding of the 3 retirement plans that SDCERS administers and determines that one aspect of the city's plan is more advantageous to members than that aspect of the port and airport plans, each of which are governed by PEPRA, but the city is not. I alluded to this earlier. Martha advocates to staff that SDCERS' board should adopt policies shifting the administration of the port and the airport plans away from PEPRA's requirements to be more consistent with the city plan. What fiduciary issues are implicated by this hypothetical?
Well, we're just obligated to follow each of the plans.
Right,
as
you
written.
can't do it. You're not the settler. You're not the one who's designing the plan. The plan is designed under applicable law that is adopted by others, not you, and you are to administer those plans.
So put another way, we're here effectively to administer the plan, to do what it says, and not necessarily to make the world a better place. Maybe a
Correct.
sort of ridiculous comparison.
Correct.
Right.
And you have really important fiduciary responsibilities in terms of how you go about administering the plan, because discretion is, and judgment and decision-making is assigned to you. You have plenary authority, as the LaSera decision said. You're a fiduciary board. You're not a legislative board, but you're a fiduciary board. And so you have to use this prudence and this duty of loyalty and this expertise with all of your important decision-making. And that independence from others is really important in terms of how you are set up, that you are not to be manipulated by the employers trying to play less or the members who might be trying to get more. You are to be the wise administrator who's making the tough decisions about how to manage this complicated portfolio and large group of members' benefit rights appropriately.
So related to this question, maybe this is a question for Greg. So remind me, how do plans change? How do the details of a plan change? Is it a vote by the members? And
Certainly. So we have 3 plan sponsors, and each of the plan sponsors is responsible for their own plan document. The city is unique in that their plan document primarily resides in the municipal code. So you would have to go through a change in the municipal code. Certain aspects of it are in the plan charter, which has a higher level of being able to change through the voters. City charter, excuse me. But the port and the airport, those are internal plan documents controlled largely by their oversight boards. But as Ms. Dunning represents, those are the responsibility of the plan sponsors, and they regularly update their plans, similar to like when the city opens or closes a tier. Same with the port and the airport. They notify us of the new benefit changes, and we administer them appropriately.
so then let's say if the airport plans decides that environmental risk is a significant investment risk to that portfolio, and they decide that environmental risk should be part of the analysis in selection of managers and investments. Now there's formal recognition by the plan that they want E to be part of the investment decision process. Does that then, what does that then do to our fiduciary duties, and what does that then do to our fiduciary duty as it relates to plans that are not consistent with each other?
I would analyze that question similarly as the LaSera decision addressed the administration topic presented there, which is, but it's on the investment side of the house, and it's a little bit like divestment mandates. Does this fiduciary board, is it able to comply with that new provision of, in this case, the airport plan, and comply with its fiduciary obligations of prudence with respect to the portfolio construction or not? Certainly. Good question. So Mr. Rademacher answered that perfectly in terms of San Diego law. I would add the overlay of the California Constitution, which has affords constitutional contract protection to the vested benefits of your members, which means that the benefits of your currently employed members cannot be diminished without a comparable new advantage being provided, unless the change is consistent with the theory and successful operation of the plan, and providing a new advantage would compromise that theory and successful operation of the plan. And that was the topic of the Alameda decision, which is the 2020 California Supreme Court case that I mentioned, or was the primary topic of that decision, was whether or not statutory changes to the county employees retirement law that changed the way that compensation earnable was defined in certain ways, whether that was constitutional or not. And the Supreme Court said ultimately it was, but it had to go through that whole California rule analysis to get there. So there are limits on what plan sponsors can do as they, and the topic came up earlier of Prop B. That was another situation where the court said, no, you didn't do this properly. You can't close the plan without meeting and conferring compliant with the rules. So there are limits even on the plan sponsors. Yes. All right, great questions. All right, this is our final slide, other than the final questions, I guess. Fiduciary compliance. And this was a mouthful, but hopefully it all sounds very familiar at this point. The board must use informed judgment, act in the overall best interest of your members and beneficiaries in a manner that's consistent with applicable laws as you exercise your plenary authority over the administration of SDCERS and the investment of its assets. Remind yourself always, you're not allowed to be arbitrary or capricious. If one of you is saying, this is a completely arbitrary decision, I don't understand why we're doing that, more discussion is warranted, probably, on the board, so that you get to the point where hopefully you all agree that whatever you're contemplating is not arbitrary. It needs to be consistent with your fiduciary responsibilities, rationally related to information presented to the board by your in-house and outside consulting experts. And with that, I thank you for your time. You've been fantastic.
Can I insert one last question?
Of course.
Okay, sorry. So I've been noodling on the affordable housing example at the very beginning. And so that example started out with the CIO saying we should do housing, which has an allocation to affordable, national footprint. And then eventually there is an allocation to San Diego that seems to meet, that would meet all the check boxes. I would like to flip that. So let's say the CIO comes in and says San Diego housing, or maybe not the CIO, let's say however it comes up in the conversation, we're like, we want to allocate, we see an investment case for affordable housing in San Diego. We think there's a real strong case for that. Now it's on the burden of the staff and the committee to prove that investment meets all the check boxes that would be consistent with an investment that adds risk return attributes to the rest of the plan. So it gets to the same place, but it flips the decision making, and and the decision-making process. How does that sit with sort of under this whole conversation around fiduciary and standard of care?
I would suggest that what the CIO is asked to do is not to prove what the board has determined, but rather to assess whether the risk-adjusted return expected from the San Diego-based investment opportunity is consistent, is appropriate from the perspective of that expertise that she brings to the decision-making, as well as your investment consultant. So it's not proving something that has been determined based on something that is not grounded in that expertise. It's following a direction of the board to determine whether that opportunity is one that should be considered or not, and really leaving it open. And that is important for this board, to come at these issues with the open mind of being able to receive the expert advice in a way that might be a different result from the one that you, from a values perspective, wished it had been.
But Ashley, just to go a little further, it was, let's see, El Paso, and let's say there's three options, affordable options, affordable housing option investments. One's in El Paso, one's in Boston, one's in San Diego. And the investment committee looks at them and determines they're equal in terms of value. Nothing prevents us at that point from saying, well, let's invest here, right?
That's what a lot of Department of Labor advice over the years has said. It's sort of the equal, if all else is equal, then, and even the more recent advice that's in litigation right now from the Department of Labor says that, and that doesn't apply to you, it applies to private plans under ERISA, but we do look to it sometimes for guidance, that one shouldn't necessarily look askance at a San Diego opportunity simply because it's in San Diego. But you really do need to do the analysis to make sure that that is, in fact, you're comparing apples to apples.
Yeah, and I think it's important in context. We had a workshop back in February, I think, with one of the people speaking, suggesting that where you can justify investing locally, that's a good thing from a public relations perspective and everything else. But we would have to justify that it was more or less equal to the other options out there.
Or assess.
Equal or better is what I would say.
Or assess, is it supposed to justify, right?
Yeah.
That's what I heard.
Right,
Ashley.
right. And recall, a person presenting like that is not a fiduciary. They don't have the responsibility for investing the funds in a manner that is fiduciarily appropriate, and so you take it with a grain of salt.
Are there any other questions for our fiduciary council? No? Well, on behalf of the board, I thank you for providing us this very thorough training. It was very helpful.
Thank you.
And we'll look forward to hearing from you again next year.
Thank you. All right, I appreciate seeing all of you.
So at this point, do you have any further comments, Johnny? Yes, I was going to take a break. So why don't we reconvene at 11? Thank you. 9 minutes. Why don't we go ahead and get started? It's after 11. I don't know where Greg's at.
Let me know.
Okay. You ready, Johnny?
Sure.
Okay, so moving on to the second information item, insurance and other protection for board members on SDCERS Board of Administration. Johnny, would you like to go ahead and present this item?
Yes, thank you, Lisa Marie, and good morning, board members. My short presentation dovetails into the presentation you just received. Ashley, thank you so much for that great education. Board members, thank you so much for participating. Our hope is that that education really helps this board makes the best decisions it can for the membership and SDCERS as a whole. Notwithstanding that, our decisions are subject to public scrutiny. You've heard, you've seen that. Our decisions are even subject to judicial review. So if you recall earlier this year, we had a public speaker come in and threaten to sue SDCERS, even threatened to sue members independently as part of their decision-making process. And as difficult as that is to hear, that is one of the things we deal with as public servants. So a board member asked me to say, well, what protections do we have in place for doing our job? And so this presentation helps fulfill that request. Ashley and I wanted to point out, though, that board members, SDCERS has statutory immunity for discretionary decisions it makes. So you follow the process, you make a decision within your authority. The law says you have immunity for making those decisions. So if we were to look at the courts, that we'd hope the courts would dismiss that case. But that still doesn't stop someone from filing an action, right? So what happens if a member files an action against? What protections do we have? I want the board members to know that California law and the government code requires SDCERS to defend and indemnify you for acts within the purview of what your job is. So you're here voting, making decisions. If you are sued, SDCERS is required to provide you a defense attorney and indemnity for any damages or anything that results out of that. Coupled with that, part of that defense package that we have here at SDCERS is SDCERS purchases fiduciary liability insurance to make sure that we have enough assets to address the situation. That includes directors and officers liability in addition to the insurance for the entity itself.
So Johnny, if that
Yes.
threat was a reality, so then we would have been provided counsel.
Yes, so hypothetically, if, let's say, a board member were named in a lawsuit for performing their jobs for SDCERS, the analysis would be whether you need to have independent counsel, if the counsel that represents SDCERS should also be your counsel, but you provided a defense for that. Yes.
And that legal coverage extends for the time served. So let's say a board member steps off, lawsuit drags on.
Yeah.
That person is no longer a trustee. That person is still protected and being provided legal support.
Yes. So if you rotate off the board, but you're sued for the actions when you're on the board, that defense would continue. Okay. I also want to talk about other protections you have in different situations. SDCERS does purchase commercial general liability insurance, so someone should get hurt here physically, example. Employment practices liability insurance, claims for discrimination, harassment. Individually, you're provided workers' compensation. So if you should be hurt pushing a button here, doing your job, it's something we could hopefully get covered for. And then you also, as you may know, reimbursement for expenses you incur doing your job here. Okay. That is it. So I really appreciate it. If you have any questions, otherwise you can talk to me after the meeting.
Johnny, I have a question. So this is great. So why am I writing a check for $10 every year for some additional whatever protection.
Sure. Good question, Chris. So I believe what you're talking about is your personal decision to buy a policy with the fiduciary carrier for a waiver of recourse. And so what the law says in California is that a retirement system can purchase fiduciary insurance. But part of that statute also says, but if a board member of a system is found liable for breach of fiduciary duty, that insurer has the ability to seek recourse against that individual board member. That's what the law states. That's something that you and I cannot change. But as a product, the insurer, our insurer, has allowed a member to have a separate contract with that carrier and say, well, in that nearly impossible circumstance that I know historically hasn't happened, if an insurance carrier wants to then seek recourse, we won't seek recourse if you buy your own policy. So SDCERS cannot pay for your personal benefit, you know that, and so part of that is I cannot, on behalf of SDCERS, pay for that personal policy. So that's why you have to fork up your own premium. Thanks. Yep, thank you.
Other questions?
I do have a follow-up question. So let's say there's a discovery process, and it costs time and effort and expenses. And let's say there's depositions and all such, very complicated scenarios. It gets quite drawn out, takes time away from work, creates stress, anxiety. How is that compensated by the plan?
I'm not confident it would be compensated from a money standpoint. I know that we provide you a defense, but it is part of the process that you participate in that defense. So if you're asking if you would be reimbursed for your time, I don't believe that is part of the coverage.
So if I'm a prudent person and I'm thinking about my downside here, my legal liability is covered, but my sort of the externalities of that situation is not covered.
Yes, I believe so. It's part of the job.
Any other questions for Johnny? No.
All right, thank you.
Okay. So this finishes our business operations agenda, and we'll be moving to Section 6, our Disability Committee. So I'll be asking our Disability Acting Chair, Paul Lotz, and thank you for stepping in. Go ahead and take it away.
Thank you. The Disability Committee met yesterday, and as Disability Committee Chair Tom Battaglia was unable to attend our September meetings, I served as our Disability Committee's acting chair. We have 6 action items on the consent agenda, and I'm going to pull item 5 for a separate vote. Are there any other action items the board members would like to pull? We will discuss consent items 1 through 4 and item 6 and vote on these items as one motion. Starting with consent agenda item 1, staff's recommendation to approve the industrial disability retirement application of Patrick Doy. The committee approved Mr. Doy's application for industrial disability retirement as his application was supported by evidence of being permanently disabled, being attributable to his work duties and causing the need for his leaving city employment. Are there any questions from the board on this item before we move to consent item 2? Hearing none. Moving on to consent agenda item 2, staff's recommendation to approve the industrial disability retirement application of Deborah Foster. I'd just like to thank Mrs. Foster for joining us today. The second row back there. Thank you. The committee approved Ms. Foster's application for industrial disability retirement as her application was supported by evidence of being permanently disabled, being attributable to her work duties, and causing the need for her leaving city employment. Are there any questions from the board on this item before we move to consent item 3? Hearing none, moving forward onto consent agenda item 3, staff's recommendation to approve the industrial disability retirement application of Carrie Shannon Greaser. Committee approved Ms. Greaser's application for industrial disability retirement, as her application was supported by evidence of being permanently disabled, being attributed to her work duties and causing the need for her leaving city employment. Are there any questions from the board on this item before we go to number 4? No questions. Moving to agenda item 4, staff's recommendation to approve the industrial disability retirement of Connie Thomas. The committee approved Ms. Thomas's application for industrial disability retirement, as her application was supported by evidence of being permanently disabled, being attributable to her work duties, and causing the need for her leaving city employment. Are there any questions from the board? No. Moving on to consent agenda item 6. Hearing officer's recommendation to deny the industrial disability retirement application of Ramon Reyes. The committee denied Mr. Reyes' application for industrial disability retirement based upon the hearing officer's findings and conclusions. Are there any questions from the board on this item before I move on? Move to approve consent items 1 through 4 and item 6. No? All right, let me go current. I move approval of consent agenda items 1 through 4 and consent agenda item 6. Please record your votes. And it looks like we're waiting on the one to finish processing. There it is. Thank you, Rosie. Moving on to, go ahead.
And with all votes in, Mr. Acting Chair, this motion passes 8-0.
Thank you, Rosie. Moving on to pulled consent agenda item 5, hearing officer's recommendation to approve the industrial disability retirement application of Lorraine Gain. Lorraine, thank you for sitting here while we get to your item and for your patience with us, and also for your 31 years of service to the city. And we see how hard it is for you to walk up here, and we recognize that. The committee approved Ms. Gaines' application for industrial disability retirement based upon the hearing officer's findings and conclusions. Additionally, the committee also approved the payment of Ms. Gaines' attorney fees incurred as a result of the hearing process. At the committee meeting, SDCERS General Counsel raised a question on whether the board was able to approve the payment of attorney's fees. Council was directed to review guidance on the board's ability to pay attorney fees prior to the board voting on this item today. Based upon council's review, the chief executive officer recommends the board separate the approval of Ms. Gaines' industrial disability retirement application from the recommendation to pay attorney fees, and discuss the payment of attorney fees at a future meeting. As such, I offer a substitute motion to approve the industrial disability retirement application of Lauren Gain. May I please have a second to the motion as it is? Okay. Would any board member like to speak on this consent agenda item before we vote? Looks like the votes have already come in. I don't see any hands.
Paul, could I just make, and you articulated this well, but I just wanted to let you know that this other issue is not slipping through the cracks. We will address it.
Chris, thank you.
We'll discuss that at a later meeting?
At a future meeting, correct.
Meeting, okay.
That will give council the opportunity to look further into it and present us with what we can or cannot do,
Okay.
and where to go from there. And then we'll look at it again and approve or deny that part of it.
Okay, because it's starting to remind me of that last case that we had to deal with.
How much are we talking about?
I don't have the numbers. We'll have those, I'm sure, at a different time. There it is.
And with all votes in, Mr. Acting Chair, this motion passes 8-0.
And I apologize, just a point of order. Could we clarify who seconded the motion?
There was no second.
Because of the committee.
Should
I'll
we have
second the
someone?
motion.
Okay.
Thank you.
Okay, thank you, Chris.
Yep.
And thank you, Rosie. Okay. Staff provided a disability status report, and it is available in the board agenda package. The disability report provides an overview of the disability application review statistics, highlighting the caseload is in good shape with all but one case within the 18-month processing window as of the conclusion of this meeting. Are there any questions and comments from the board members or staff? No questions. Well, thank you, and back to you.
All right, thank you, Paul, for serving as the acting chair, and thank you for your report.
You're welcome.
So we'll move to Section 7 on Business and Governance Committee. So I'd like to ask Acting Chair Chris Brewster to provide us a report.
Thank you very much. We had a fun Business and Governance Committee meeting yesterday. Yep, there was some entertainment. Sorry you weren't able to be there. So there are 5 action items that you see on the agenda. And I guess first question is, does anybody want to pull any of those 5? Yep, Cliff.
I need to recuse myself on number 2.
Got it. Is there a way to do that easily? Well, you're just gonna you're gonna abstain,
What's
I
that?
guess, right?
Do I have to abstain on the entire consent agenda then?
I didn't think about that.
So we'll pull number 2 for a separate vote. And Cliff, when we get to number 2, would you please excuse yourself from the room? Thank you very much.
I have a question on one of the modifications to policy on number 5.
Yeah, hold on just a second, Michelle, because I wanted to speak to number 1, and then we have a modification on number 5
Okay.
that we'll talk about, and then we can, you can address whatever you think once we talk about the modification. So just on number 1, we had a discussion along these lines. So we have 6 board meetings a year. And Greg put in this calendar 3 additional meetings for the, how do you define that?
Networking and education event.
Network and education events. Those happen to be in months that we don't have board meetings. And I looked at that and I thought, for my scheduling, to do things, it's helpful to have full months off to be able to schedule things so that I don't have a conflict with the meeting. And so the question really, and it's just a discussion question, would you rather that those 3 tentative meetings are scheduled in the same months and maybe proximal to existing board meetings, or would you rather that they are in months where there are no board meetings? And there wasn't a resolution, it was a discussion, and we thought it most appropriate to bring it to all of you to see what you wanted.
Because I'm on other boards, and it typically gets really quite crammed in the same quarterly cadence. I would prefer when we off-cycle meetings, so that we're not jamming all the SDCERS meeting in the same quarterly time period. That's my preference.
And I have a question. Those social events, I know they're technically board meetings, but they're not required, right? They're optional.
Are definitely optional. They're really optional educational opportunities for the board.
Okay.
All right, so hearing no one who has heartburn over the way Greg scheduled it, then we're good to go. So that's that one. And then let me just go through those. So that was the first issue. It's number 2 I'm not going to talk to for the moment, right? Okay, so on number 3, there was a staff recommendation to approve an agreement with Nth Generation for the replacement of the storage area network solution. And the only thing that I would note on this is that Michelle noted that the existing system was purchased in 2012 with an expected support term of 5 years, and she's squeezed every last bit of life out of it, which is what requires this action here. And then Johnny talked about the staff recommendation to direct the CEO to retain Noonan, Lance, Boyer, and Branch as litigation counsel. There was a brief conversation about would we not RFP something like that. Brett helped us through this in the sense of looking at it, and I think he had a comfort level that this was a very favorable agreement. Is that correct? So we were comforted by that. And then on number 5, on these various policies, we decided to make 2 modifications to 2 of the policies. First one is in the communication policy. It's amended under item 3B to clearly state that if a news story contains inaccuracies, SDCERS shall contact the publication and request a correction. The former language was may. And you'll remember at our retreat in February, there was a desire of the board to be a little bit more out front on these things if we were inaccurately represented in the press. Second one is in the fiduciary council policy. It's amended under item 3, which addresses fiduciary council reviewing SDCERS agenda to clearly state that the fiduciary council will review agenda materials, and for matters that fiduciary council believes may warrant fiduciary council's attention, that such matters will be discussed with the board president, committee chair, chief executive officer, general counsel, or the chief compliance officer prior to providing comment and guidance to the board. So that revised order was intended to reinforce that fiduciary council is an attorney for the SDCERS, which acts through the board. So those are the 2 changes to the policies.
Are those changes what's listed in front of us or not?
I can't answer that question.
Okay.
They were in addition to what, excuse me, they are in addition to what's in your board
We
package.
can't see it on the screen then?
We will not be able to see that on the screen at this moment.
Okay.
So Michelle,
I just, a real quick question, clarification on the selection of the independent non-board members of the investment committee. The policy speaks to the selection. How is the need established? How does that part happen? It doesn't talk about how it's initiated. It just talks about selection. So I'm just curious about
I can speak to that.
selection.
No, I think you found a point. It doesn't talk about the need. I think that's something that the investment committee determines itself, and this is an avenue to help fill that need. But there isn't a written process for determining do we have a need or not.
And if I can jump in, I think this also dovetails in our, for the past year and a half or so, talking about board effectiveness and looking at what are the skill sets required by the board and by the committees, and do we have those skill sets? And if we're lacking in those skill sets, how do we overcome that? Is that through outside experts or recruiting additional people in? So,
Right. And I understand that. I understand that point, and it makes sense to me. Thank you. But when I read the policy, it talks about allowing folks to submit an application to be considered as a non-voting member, and then those applications go to the Business and Governance Committee. So I didn't see the continued interaction of the Investment Committee in that decision-making, and that's why I'm asking. It just, I don't know if we need to add something to establish, does the Investment Committee initiate that need? Is it initiated by the full board? Is it initiated by Business and Governance? But I think that clarity would.
I think those are some good ideas, and we can come back with some further clarifications on this. And these types of comments have come up before, but what we've tried to do is anything having to do with governance, we've tried to have the governance committee be kind of the central focal point. And so when we have changes to investment-related charters or investment-related process documents, first we would go and talk to the investment committee and say, these are the changes we want to make, and then we'd present them to the Business and Governance Committee for codification and on to the board for final approval. But I like your idea.
I was just looking for who the we is.
Yeah.
Yeah, I would add, though, it would be helpful like at the investment committee meeting that we had yesterday, if we could have just had this on the agenda, then we could have saw it firsthand as a part of our governing meeting yesterday. But to your point, it only goes through B and G, and then we see it at the full board. But what would it harm for us to also see it at the investment committee?
In retrospect, that probably would have been a good idea.
So can we do that in the future?
Sure.
So if it comes back, can it come back on the investment committee and then we can vet it?
Yeah, something, when it's directly investment related, that sounds like a
That
really
makes sense,
reasonable
Chair
thing to
of the
do.
Investment committee? Okay,
You stole my thoughts.
okay.
Thank you for that.
I've
Very-
heard a
very
couple of
helpful.
times now that historically, this has been the case, that there would be non-board members sitting in on the investment committee. Did I hear that right? And if so, like, how long ago was that? Did it accomplish its purposes?
So the last time it happened was we brought in a member from Sempra, Karina Coleman, came in as a non-board member of our community on the investment committee. And she served as a non-board member on the committee for a while before the city appointed her to actually be a board member.
Got it. Thank you.
Real quickly, Lisa Marie, to your point, we did put this on the investment committee's agenda in July.
Okay.
So we had that forethought, and
Okay.
there was no comment. So then we brought it to B&G this meeting.
Great, thank you.
Yeah.
I do think it's worth mentioning here the context for everyone's benefit, which is, from where I sit at least, there are challenges in bringing onto the board a broadly diversified roster of qualified and committed community members to serve the way we all do. And it's especially relevant for investment professionals by virtue of the disclosure requirements under California law. So I think one question is if there were to be a community member on the investment committee, would they need to make the same disclosures under the Brown Act that the rest of us make? Yes or no, do you know?
It's a good question. I don't recall what we did back in 2015. So we need to look at what we did before. But
think,
I
when you
believe
find out,
under,
you could let us know, that would be very
yeah,
helpful.
I believe under our conflicts code, we do have them disclose or file a Form 700.
Okay.
So that's relevant in terms of conversations
Yes.
that Greg or senior staff or the CIO or any of us may have with people from time to time.
Okay.
Any other questions? So on behalf of the committee, I'm going to move items 1, 3, 4, and 5. And we don't need a second, so any comments? Please vote.
With all votes in, Mr. Acting Chair, this motion passes 8-0.
Okay, Cliff, you want to? Item 2 is staff's recommendation to select Dell as our Microsoft Enterprise licensing vendor. And Michelle explained that Microsoft does not allow us to contract directly with Microsoft. We have to contract through whatever, authorized vendors of Microsoft or whatever. And Dell turned out to be the best one from their perspective. By the way, it allows migration to Microsoft 365 and some other things, so it's going to improve things quite a bit. Amount not to exceed, whatever it says, $325,000. Questions? So I will move that on behalf of the, well, Paul will, on behalf of whatever. It doesn't make any difference. We got a motion in a second. Please vote.
With all votes in, Mr. Acting Chair, this motion passes 7 with one recuse. So I'm going to have to fix that in the system. I apologize.
And was that Cliff? Was that an abstention for Cliff or what?
Yes,
Okay,
yes.
okay, got it.
Yeah.
Thank you. let's see, I think that covers that. So just on the reports, give you a quick overview of that. First, we gave a warm welcome to Natasha, who's been on this board twice, worked in two different stints with the city, the airport, the zoo, SeaWorld, and probably other things that I forgot. But we welcomed her back and asked her not to go out and be recruited by somebody else and stick around for a while. So we're happy to have you here, Natasha. She wanted to acknowledge Victoria's work. I guess, is Victoria here? No. And her team for standing in after during the vacancy. She mentioned that the call center is now fully staffed, and that two retirement counselors, Sarima and Celine, are working on translating some SDCERS webinars into Spanish for some members who prefer Spanish. Monty Pareto explained that the Unified Port District's plan amendment has been approved, and it effectively ends a 5-year waiting period, long waiting period for membership in SDCERS. And he also explained, although this is very complicated, how the police Prop B tiers are being regularized. And then Michelle, this is important for board members. Michelle talked about how she is, or they are, implementing a new phishing campaign software. And so all of us, as well as staff, can expect to see fake phishing emails sent to us to see if Michelle can trap us into inadvertently clicking on links. So you are forewarned. Use caution with your inbox. And then Johnny gave an update on the request for the city to review its additional contributions plan provisions. You'll recall at the last meeting, we modified our policy such that now our policy allows active members to make additional contributions, but there has been an effort on the part of Johnny and Greg to contact the city and ensure that they want to continue to offer that benefit. And that's it. Any other questions on business and governance? You missed a fun meeting. Okay. Thanks, Lisa Marie. That's it.
All right. Well, thank you, Chris, for the committee report, and thank you also for serving as acting chair.
Sure. So
at this time, I'm going to ask our investment committee chair, Cliff, to provide us the investment committee report.
Thank you, Lisa Marie. Yesterday afternoon, the investment committee met. I don't know if my colleagues would agree it was a fun meeting or not, but it was a very productive meeting. With all seriousness, there are 6 action items. The first 3 action items deal with manager selection and are therefore delegated to the investment committee. So these items are: 1, approve a $25 million commitment to Sabal Debt Opportunities Fund 3 for the real estate portfolio. Do we have any? Okay, we don't have staff presenting. This fund is a non-core debt fund focused on multifamily investments. This investment will help balance the exposures in the real estate portfolio, as SDCERS is currently underweight both non-core real estate and multifamily. Sabal is an experienced manager with a strong network of relationships to source deals. Both of the prior funds in the Sabal series have had strong performance to date. SDCERS also benefits from a fee discount due to the relationship with Makita, which is the real estate consultant, as people may remember. Pardon me. This item was approved 5-0, and no additional vote is needed. Corinna, do you want to make any comments on this? I see your hand on the microphone.
Just a little bit of context. We have, as you mentioned, the the 4 funds, the 2 first are for the real estate portfolio where we are underweight. So this helps to correct our underweighting to real estate as an asset class as a whole. And the next item, which you're about to cover, also does the same. So it helps to bring us back to towards our target weighting of 11% to real estate.
Great, thank you. As Karina mentioned, the second action item is the approval of a $50 million follow-on commitment to the CBRE U.S. Core Partners for the real estate portfolio. At the July meeting, the board approved the real estate investment plan for fiscal 2025. This included committing $115 million to core strategies. Staff and Makita identified the CBRE U.S. Core Partners Fund, easy for me to say, I know, as a top candidate for an additional contribution. The additional commitment to CBRE will reduce the effective investment management fee from 84 basis points to 79 basis points. This fund has outperformed its benchmark over all periods. This item was approved 5-0 by the committee. No additional vote is needed. The third relevant action item here is the approval of 2 related investments in infrastructure. One is a $60 million commitment to the Brookfield Supercore Infrastructure Partners Fund, and also a $60 million commitment to the KKR Diversified Core Infrastructure Fund for the infrastructure portfolio. Staff and Aon presented 2 core infrastructure funds to fill the additional 1% allocation to infrastructure that was approved at the May 2023 meeting. For this allocation, staff sought to invest in open-end core funds to balance the risk posture of the infrastructure portfolio. Brookfield and KKR fill the role of this allocation well, as both funds focused on the lowest risk core infrastructure investments. Both portfolios are highly diversified and have very stable revenue profiles. This item was approved 5-0 by the committee. No additional vote is needed. I would mention to our colleagues who are not on the investment committee and who are not present that all of these managers, with the exception of CBRE, came in person and made very professional, I think very impressive presentations to the committee. There are 3 additional action items. These remaining action items are on the consent agenda. Before I review these action items and make a motion for the consent agenda approval, are there any action items the board members would like to have pulled for discussion and a separate vote?
Cliff, I'd just like to make a comment on number 1. It doesn't have to be a separate vote. Is it okay if I just comment and then? Sure. With great respect to the investment committee, I have continuing concern about our investment in private equity and private debt. And that is based on a feeling of a lack of long-term record that it will outperform other investments that we have. The lack of mark-to-market, the opacity, and other things along those lines. I think back to something Brett said this morning about how if a member has a concern, then, register a no vote. I don't want to do that because I respect what you're doing. I just disagree on that point. And I just wanted to register that concern. Thank you.
Well, you're welcome. And I think that in the spirit of how we're all jointly fiduciary, it's important that if people feel strongly about this matter or any other matter, that in the context of our larger process, they express their views. We are a democratic process, and every vote matters.
Yeah, Cliff, I used to be just 1 of 13. Now I'm 1 of 11. I'm feeling more powerful. Thank you.
Any other questions or comments? Okay, then let's go through this discussion quickly. The first is the portfolio structure annual review. We had both Corinna and Katie Comstock from Aon helping with the conversation. Every year, Aon conducts a portfolio structure review in order to ensure that each asset class in the portfolio was implemented efficiently in line with stated objectives and the correct risk posture. Over the past several months, staff and Aon have worked to methodically conduct structure reviews of each asset class in the portfolio. There are no recommended changes to the current portfolio structure. This item was voted on and approved by the committee 5-0. Do we do each action item motion at a time, or do them at the end?
We can discuss all three and then take one motion at the end. It'll be fine.
The second item is the rebalancing model portfolio review. And for this, Anders and again, Katie Comstock from Aon helped with the conversation. SDCERS reviews its rebalancing model every 3 years in order to examine the balance between portfolio tracking error and rebalancing costs. Aon reviewed SDCERS' rebalancing model and affirmed that it is appropriate and in line with best industry practices. Staff made a few refinements to the model over the past year, including automating data extraction and developing compliance alerts when rebalancing thresholds are triggered. This item was approved by a vote of 5-0. And then the third item in this consent agenda is the investment policy annual review. And Demetrius and Katie helped with the conversation. Staff and Aon review and update the investment policy statement on an annual basis to ensure that it remains appropriate for the portfolio, incorporates any structural changes, and reflects best practices. This year, the IPS was updated to incorporate portfolio guidelines that were introduced as a result of the portfolio structure reviews conducted over the past several months. In addition, the private equity secondary benchmark was updated to reflect a global stock market index rather than a mix of a U.S. and a non-U.S. index. This item was voted on and approved 5-0. I move approval of the consent agenda items 1 through 3.
Mm-hmm.
With all votes in, Mr. Acting Chair, this motion passes 8-0.
Thank you, Rosie. An important information item to share having to do with total fund performance report for the quarter and for the fiscal year ended June 30, 2024. Corinna, do you want to say anything before I make some comments, or what's your pleasure?
Sure. I'm happy to comment at a high level. So for the fiscal year, we underperformed the benchmark by about 167 basis points. What we are seeing is detraction coming from specifically private equity and, to a lesser extent, infrastructure. So the issue with performance that we're seeing on the 1 year, we also see on the 3 and 5, and it's also due to these same areas of the portfolio. So we have relatively strong or in line with expectations performance on our public or more liquid assets, and some near-term underperformance on our private equity investments and, to a lesser extent, infrastructure. So I wanted to provide that context. Within our private equity, we are a little bit more tilted toward growth equity, and growth equity has struggled in a higher rate environment. So post-2021, growth equity has not performed as well as buyouts, and our portfolio, our private equity portfolio, is more tilted toward that style, specifically through our investment with Stepstone. We are going to be looking at the pacing and the annual plans for both of our private equity market advisors at our November meeting. Thank you.
A couple of things to add here. First, for the record, for the fiscal year, the actual return of the fund net of fees was 7.2%. And again, underperforming the benchmark, as Corinna mentioned, which had a return of 8.9%. So the return for the overall portfolio exceeded our actuarial assumption for the period. Underperformance in the short term, nobody likes, but it is what it is. I'd also add for the record that there's a Stepstone annual conference coming up later this fall in New York, and Demetrius and I both will be in attendance. So we may have additional comments to share with our colleagues after we return. There are quite a number of reports for your reading, but we're not going to touch on them
Cliff,
today.
excuse me, could I comment on the return thing that you just spoke about? I have a question and then I have a comment. My question is, on our 7.2, does that, and it's obviously net, or intended to be net, is it net of the expenses we pay our advisors? Yes. So it's net of the fees to Aon, for example, and so on?
Yes.
Thank you. There's a lot of discussion about whether it's best to, and again, respectfully, a contrarian view here. There's a lot of discussion about whether it's better to invest actively or passively, right? And this has been discussed by a lot of pension systems around the country. I noticed in June of this year that the Center for Retirement Research at Boston College did a study of pension systems, which I will share. I'd be happy to share. But found that, generally speaking, over the long haul, passive index investing by pension funds would have outperformed active investments by a significant amount, what I would consider a significant amount. And I had the opportunity to attend a Wharton educational seminar in 2023 where they showed that the 5 and 10-year rolling average returns on I think it was a 75-25 mix of bonds and stocks, U.S. stocks, produced something between 9 and 8.9% respectively over the studied period. I will only suggest or ask that the investment committee have a look at the study, and see what you think of it. It's the direction I would prefer that we go, but we have an investment committee for a reason. Thank you.
I think that if we can get a copy of that report and then circulate it appropriately, that would be helpful as a first step, certainly.
And share with staff as well.
Chris,
Well, of course.
what did you say the timeframes for that study was?
So there's two different studies here. One of them is the Wharton one I was referring to. That was between 1900 and 2022. So those were the returns of 9 and 8.9 respectively. They were rolling averages for 5 and 10-year periods over that time frame. On the study from the Boston College study, that was from, I believe, 2000 until 2022. And I'm sure you get a copy, and it's pretty easy to read through. It indicates that before the Great Recession, active investing by pensions was slightly better. And since then, active investing was not better. It was worse.
It was a 10-year time frame for the first one.
Again, I'm going to share this with you. And you remember our issue with the glasses yesterday? I left my eyeglasses at home, but from what I'm reading, looking at this while we're speaking, they studied between 2000 and 2022.
Thank you.
Yep.
And I have a copy of that report, and I'll circulate it amongst the board. And Chris, was there something from Wharton that was relevant to circulate, or just the Boston
Nope,
College?
I can send you a copy of that as well. Thanks.
Appreciate that. Thank you.
You're very welcome, and thank you to everyone who participates in our process. I have no additional comments from the investment committee. Are there any other questions before I go back to our president? Thank you.
All right, well, thank you, Cliff, for the committee report. And now we are now going to section 9, questions and comments. Do we have any questions, comments, or educational or session reports from any board members?
Yeah, please. No, go ahead.
Do we have any questions from, go ahead.
I just wanted to make one comment, which is that I personally like to read the board materials on some device other than my iPad. And so Rosie has kindly assembled the board documents into PDFs, including all the attachments for each one of the committees for me. If anybody else would prefer that, I'm sure she'd be happy to share it with you as well, and you can look at it on your laptop instead of pulling out your iPad.
I would prefer that as well.
That would be very nice.
Thank you.
We'll be in touch.
Thank you, Rosie. That made my life a lot easier.
No, just aren't they were screened.
Any comments from staff, Greg?
Oh, absolutely. First, to begin my comments, I wanted to express my appreciation to Paul Lotz and Chris Brewster for stepping up to be our acting chairs. Greatly appreciated. We appreciate that very much. And also, I wanted to appreciate Brett for filling in temporarily for absent committee members, because without Brett dedicating more time, we would not have been able to hold the Disability Committee, which is very important in administering the benefits, or the B&G Committee, where we had some very important operational task things to take care of. So thank you very, very much. I'd also like to thank all the board members who were able to attend our August 15th board network and education event. It was a lot of fun. It was also very educational. And I know it was hard to get everybody there, but I really appreciated those that had the opportunity to stop by, whether for the entire event or part of the event. It was just, I really appreciate the community that you helped build amongst ourselves. And along the lines of being thankful, I'd also like to say that we're excited to bring Natasha Calera on as our new Member Services Director. Natasha joined us at the end of July, and she quickly is establishing herself as a very valued team member in that short period of time. Her leadership style, her business acumen, her can-do attitude, along with her technical skills, are already shining brightly, and as she builds a relationship with her team, our plan sponsors, and also our stakeholder groups. So welcome, Natasha. Thank you. I'd also like to recognize Norma Frank from our information technology team for her professionalism and ability to get things done. The state of California is mandating all governments to migrate from whatever their internet domain .whatever to .gov. And you have to go through the Department of Homeland Security to get this done. And so we have been using SDCERS.org for as long as we can remember. We're the only people that have any type of acronym like that, and we were denied. And I thought, well, maybe South Dakota SERS is looking for something, but that is not their acronym. So I thought maybe they were saving it for something else, but they weren't. And I just really appreciated Norma. Wave hi, Norma. Because she pushed back and said, you know what, this is our acronym. We've been using it. It's not confusing. And all the other options that the Department of Homeland Security gave us were really kind of horrible options. So thank you, Norma. We appreciate you. The deadline is 2029, but we anticipate implementing this much sooner than that. As we go through our IT strategic plan, we're going to fold this in where it makes sense as we update and migrate to Microsoft 365 and all the other changes that we're making with regards to the various platforms and changing business cards, websites, correspondence, and all those others good things. I'd like to recognize and thank Susan St. John for providing data security training and Melanie Peter for providing staff training on our compliance program since our last meeting. I'd also like to thank our IT team for navigating us through the CrowdStrike. It seems like so long ago, but it really, really wasn't. We were very fortunate that we did have some exposure. The scary part was it was right before running retiree payroll. And, you know, in that time of uncertainty, I was very appreciative of our IT team taking a big picture look at mitigating those risks and making sure that we got through that successfully. Fortunately, we were only minimally impacted, but our IT team had an immediate response, was on it in the early hours. I think it happened like at between midnight and 1 o'clock one morning, and by the time the sun came up, our IT team was already taking remediation efforts. So thank you. And I'm pleased to say that our plan sponsors some of them more impacted other than others, but they've also been able to get through that issue. And in closing, I wanted to give a special thank you to Cliff Shearson. He connected me with a very good potential board candidate. So again, thank you, Cliff. Had a very good conversation with a potential board member. And it's a good encouragement that if you do meet people in your circles of influence that you think would be good on this board, please let me know. We can try to make connections and then encourage them to apply through the mayor's application portal, which I did with this member. In addition, I gave the mayor's office the heads up that this was such a great person that perhaps there might be other opportunities that the city's looking for on their various boards and commissions that they may want to consider. With that, I've been following up with the mayor's office on our two vacancies. One is the ex officio mayor's appointment, and the other one is the city council confirmation appointment. And so I continue to touch base with the mayor's office on, hey, where are we? What's happening? And so they said, I think I reported last time they had one potential board member, but I think maybe when they saw the Form 700, they decided they wouldn't do it. But I just made that last part up. But they were close to getting somebody on, but in the last minute they changed their mind. Also, we have three board members actually whose terms are appointed board members whose terms are coming due in March of next year. So this is the time of year where I start reaching out to the board offices, the mayor's office to talk about reappointments. But before I do that, I'll be contacting those board members that are up for reappointment to see if they would like to continue to serve. Hopefully the answer is yes. We also have 3 elected members whose terms are up in March of 2025. And I'm looking at you, Paul and Brett, and then also Tom Battaglia. So we've got nomination packages coming out, I believe, in November, early November. Jessica's saying yes. We administer those elections through our own vendor. And so we've got the timeline down. So if you want more information on that timeline, let me know. But the packages will be coming out in early November. And it's about a month-long nomination period before we start mailing ballots. And with that concludes my remarks. Thank you.
Well, thank you, Greg. So we'll move to section 10, closed session. Johnny, do we have any closed session items?
We do. We have to discuss existing litigation, potential litigation, as well as your annual review of the CEO and CCO. So if we clear the room right now, please. Thank you.
Yeah.
2 minutes? 2 minutes.
Well, we'll have a break for lunch, but let's just go into closed session right now.
Lisa Marie, is then Greg going to call that ad hoc committee together? Is he going to handle that, or are you doing it?
I don't know. I'll talk to him. I'll talk to him in his feedback. Greg.
Down to 6 members.
Not really allowed to conduct further business.
Okay. But basically, they can adjourn the meeting, though?
Yep.
Okay.
Always.
Okay. So we are unable to vote on anything?
Well, there was only one thing left to vote, was this one. We can defer that one?
Yep. Just say no.
But we can't, but that can't vote. No, yes or no? Do we have to adjourn, or what do we do, Johnny?
Well, you're not allowed to conduct business without a quorum, and the municipal code says you need 7 affirmative votes to do anything anyway.
So then
So,
I just move to adjournment.
But is an information item okay?
I think if you need to close what you need to do, I think that's appropriate.
Because I thought you were going to report something out of a closed session or something.
Are we on the record now?
Yes.
Yeah.
Rosie, can we go, are you recording us?
Yes, we are
You're
recording.
back in open session. So
Yeah.
Johnny, do you have anything to report out from
Yes,
closed
there's
session?
nothing to report out of closed session, Lisa Marie.
Okay, thank you. So now,
Motion to adjourn.
so now, given that we no longer have a quorum, I motion for adjournment. Thank you.
Thank you.
Thank you, everybody.